Welcome, Energy Media readers. Today we're going to be talking about a decision by the Alberta Court of Appeal on the constitutionality of the federal carbon tax. It was ruled unconstitutional yesterday by a count of 4-1. To discuss that, we've got Professor Sharon Mascher from the University of Calgary, Faculty of Law. Welcome to the interview, Sharon.
Thank you very much.
Can you give us an overview of the decision, please?
Yeah, just at a high level, the majority of the Alberta Court of Appeal really focused on provincial jurisdiction, particularly over natural resources, and was very concerned about the implications of applying the national concern doctrine with respect to the regulation of greenhouse gas emissions under the Act on the basis of the interaction with provincial jurisdiction.
And there were two other court cases that went the other way and upheld the constitutionality of the carbon tax. What's the difference between those two decisions and this one?
Well, both the majority of the Saskatchewan Court of Appeal and the majority of the Ontario Court of Appeal were satisfied that the Act was valid under the national concern branch of the peace, order, and good government doctrine. On different bases, though, the Saskatchewan Court of Appeal was narrower, focusing on the regulation or the establishment of minimum greenhouse gas pricing standards, whereas the Ontario Court of Appeal, the majority, said that the national concern branch engaged the ability to set national standards on greenhouse gases a little more broadly.
Now, Sharon, I follow your colleague Martin Olazinski on Twitter, and I was looking over some of the comments that he had made, and he focused in on some what seemed to me to be very odd comments in the decision, such as the judge's opinion that there is no environmental crisis. I guess he's referring to the climate change, even though we have a motion passed in Parliament that says we're in a climate crisis. There was another comment about the impact of foreign oil and gas competitors somehow, shadowy cabal of influencing this debate. I've never seen that kind of language in a court decision. I don't read a lot of them, but was that unusual?
It was unusual, and it definitely wasn't language that we saw from the Ontario Court of Appeal or the Saskatchewan Court of Appeal, and so definitely some of that language attracted immediate attention from people who were taking their first read through that decision.
And I would imagine then that gives the federal government plenty of grounds for appeal to the Supreme Court.
Well, I mean, I do think that the focus will still be on the constitutional analysis. There is, an 8-7 split now between members of the various courts of appeal as to whether or not the national concern branch of the peace, order, and good government doctrine actually can support this legislation. And I think that that's where the focus of the conversation will, of course, lie.
Any chance that we're assuming that the Supreme Court will in fact hear the case?
Well, that's true. I mean, we're in this interesting situation where next month the Supreme Court will be considering the references from the Ontario and Saskatchewan Court of Appeal decisions, or appeals from those reference decisions. And so it will be interesting to see how this Alberta Court of Appeal decision is accommodated in that process.
Is there any other things that we should have talked about this decision but didn't?
Well, I mean, I would say that the majority of the Alberta Court of Appeal is focused on federalism. I think justifiably, this is very much front and center a federalism issue, but I think it's an impoverished view of federalism that the majority has adopted here. for me, this legislation tries to strike the balance between setting a standard but allowing provinces to choose in a very flexible way how it is they implement this carbon pricing, these minimum standards that are set by the carbon pricing benchmark. And that seems to me to be an example of federalism that is preferable to, for example, the federal government regulating greenhouse gases through its criminal law power, which would necessarily be much more prescriptive. The Federal Court of Appeal has recognized that this is a regulation of an evil, and then to set up a framework with prohibitions in order to engage the criminal law power would provide less opportunity for the provincial governments to design the approach they want to take. So in this way, I think that this strikes a balance. This act strikes a balance in federalism that I hope that the Supreme Court of Canada will recognize is a positive approach for our country.
One final question, Sharon, and this is an issue that came up in the debate around the Trans Mountain expansion, and in fact, I think it was referred to in the arguments that were made before the Supreme Court, and that is the importance of, or the application of, the cooperative federalism principle. So the idea being that where federal and provincial governments have some jurisdiction that overlaps, the courts want the two governments to kind of work it out in a cooperative fashion, and was this argued in this particular case?
I mean, the focus on federalism is necessarily about how that cooperative approach works. The Alberta Court of Appeal, the majority of the Alberta Court of Appeal, saw little room for cooperation to the extent that provincial jurisdiction was interfered with. It preferred to protect that jurisdiction. And so I think, of course, it's going to be front and center when we get this matter before the Supreme Court of Canada.
Sharon, thank you very much. Really appreciate your insights, and we'll look forward to chatting with you again. I'm sure we will be coming back to this issue in the near future.
Thank you very much.